Good morning, everybody. Thank you for joining us today for Ashbur's monthly webinar. My name is Amber Hines, and I'm the owner of Ashbur, where we specialize in Medicaid compliant annuities. Today, I'm very excited to have attorney Todd Watley on part 2 of our webinar. Last month, he covered topics related to Medicaid, and this month we are talking about Medicaid appeals and what you should do if your clients run into a situation where they are denied Medicaid. Todd has over 25 years of experience working as an elder law attorney and has been a past president of NELF, or the organization that helps certify certified elder law attorneys. And so Todd definitely knows what he's doing as far as appeals and just learning the Medicaid process in general. So I'm super excited to hand today's webinar over to Todd.
All right, thanks, Amber. I'm assuming they can see me and they see that I'm in a hotel room. I'm normally don't do this. I am at a conference this week, and so I'm super happy that Amber invited me to do this. And I've done this once before, and it was quite some time back, and I think we got quite a few good comments about it. And so I always like to, let's see, there we go. And so I always like to just give Amber a quick boost. Just please understand that, you know, I think Amber does a fantastic job, and she doesn't pay me to say this, I promise, but she will look at your case. I mean, she provides excellent service. You call her and she will help you analyze the case, come up with numbers and things. I mean, she will help you beginning to end. And I love that she only works with A-rated insurance carriers, which is not the case with other Medicaid annuity people. And she continues, even though she has added a few folks, everyone top to bottom is just top-notch customer service. And I just like to say that sometimes. Okay, first and foremost, okay, yeah, Medicaid appeals are not ideal. Okay, it's like, well, shoot, something's gone wrong, something's happened, and it can kind of freak you out. It can scare you, and I'll go through all of that, and hopefully by the end of this, you will see that, okay, here's the plan, here's what needs to happen. But, and I know some attorneys who do a lot of Medicaid, they won't do appeals. You know, they're like, oh, well, sorry, that didn't work out for you. No, to do good for your clients and to help fellow attorneys, if you've got an issue going on with the state that needs to be addressed, you need to appeal some cases, okay? And so I think it's kind of our civil duty to do this and make sure this gets done for not just for your client, but as the general good for elder law, okay? If you're a litigator, if you come from a litigator background, this is right up your alley, okay? This is something that you can do without even thinking much about it. There's some specifics I'll go through. But even for a lot of elder law attorneys who don't do litigation, I don't, okay? I am not a litigator. I don't like going to court, and I rarely go to court, but it's okay. You can do this, okay? I'm going to go through, and it's a mini court type case, but I just encourage you, please do fair hearings when they are needed, okay? Now, you should, unless it's something really goes wrong, you should really know that an appeal is coming. There's been something's happened in this case, and I'll talk about this some, but even when you take on a case, you need to look at it and evaluate it to say, is this going to be an issue that possibly will end up in an appeal? And you should know that the denial is coming, but I promise you, there are some times when you just get the email saying this is denied, and you're like, oh shoot, why? What happened here? But I would say it's, you know, sadly about 50-50. You know, I think 50% of the time we can see it's coming, and finally we just tell the caseworker, fine, deny it. We're going to do a fair hearing, and we'll see you there. And I'll talk about, there's some practice tips there that I threaten way more fair hearings than I do, okay? And I'll tell you how we got there, okay? But don't panic, okay? It's going to be okay. Now, obviously, and this seems kind of dumb, but I just want to go through this, try to avoid the denial. If at all costs, not all costs, but try to avoid the denial. So there's a few reasons you may get a denial that are easily avoidable. Probably one of the most common things we get are threatened with is a failure to respond. Okay, you don't get the documents into the caseworker in time, and um, that's an issue. When you submit the application, I always recommend, and I mentioned this last time, when you do the application, send in as many documents as you can. Ideally, have it fully documented. Sometimes you just can't do that. And sometimes clients don't cooperate with that. They're like, I'll get you that when I can. It's like, no, we've got to get this application in now, particularly if there's a gift. And you've got to start that penalty. The application has to go in, and you want to send it in with as many documents as you can. And because of this, you need to tell your clients, once we send this application in and we get a notice back from the state, it's a very limited time frame. And in Arkansas, it's 10 days. And so I tell the client, look, you can gather these documents at a leisurely pace right now to get those to me. But once that application goes in, we have 10 days, and that is in my contract. It says that in the contract to say you are being told when this application goes in, you have to get the documents back to us that we ask for or that the caseworker tells us they need. You have to get these back within not 10 days, but 6 days. So we have time to process it. So this is just one of those ongoing things. But if you fail to respond, if you don't get something into the caseworker, you can be looking at a denial. So here's where the threat of a fair hearing plays to my benefit. I've been doing this 25 years. Everyone at the Arkansas DHS office knows me because I've done so many applications, and a lot of caseworkers I've learned through the grapevine, they're told when you come in, if you get a case from Todd Watley, be careful, look at it, because he is not afraid to go to a fair hearing. And the way I got that reputation is I did fair hearings. And I will tell you, typically if it's a policy issue, I give the caseworker some grace to say, okay, I know you're just arguing what you were told, and this really isn't your fault. But there's a lot of fair hearings where the caseworker's just being difficult. They deny it because they want to get it off their desk. And on those cases where it's like, you're just not being reasonable. And so in my office, Sarah is the one who does the applications, and she's the one who communicates with the caseworker a lot. And so she has a good relationship with them. I encourage her to do that. I said, bite your tongue sometimes, keep a good relationship with them. With the ones that she works with a lot, she knows their kids, she knows they played, softball this past weekend, just different things come up in conversation. I'm the bad cop. Okay. She will use me to say, hey, you really, I got you this bank statement, and yeah, it was missing one advertisement page, but that's the bank statement. Take it. Or they're like, oh, sorry, you did not get us all the pages of the bank statement, so we're going to deny you. And if they've never done a fair hearing with me, Sarah says, oh, okay, Todd's going to do a fair hearing. And they're like, okay. But the ones that I've done a fair hearing with, and they were being difficult, they were not, dealing in good faith, I will tell you, I am not nice to them in that fair hearing. I will eat their lunch. I will show them the policy. I will just be relentlessly aggressive toward them, to the point where sometimes the judge is like, Mr. Watley, you've made your point. I'm like, okay, well, I want to make sure that I made my point, because this is ridiculous. And once they go through that, when Sarah then says, okay, we're going to do a fair hearing, they're like, okay, well, hang on a second, let me blah, 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 and they start backtracking, and, they start kind of working with us. And I don't like doing that. I promise you, I'm not aggressive, but you need to be, to get the point across, to say, look, let's work together, stop being ridiculous, and work with me. And so I encourage you, number one, have someone in your office that's not you who does the applications, and then encourage them to have a really good relationship. And then you're the standoff bad cop person. Okay. Now, if trying to work through this still doesn't work, sometimes calling the attorneys at the state to say, look, we've got this really bizarre case. Can we talk about this? And surprisingly, they are willing to talk to you to try not to do a fair hearing. They don't want to do it any more than you do because they're salaried, okay? They would rather settle this if they can, depending on your relationship with them. I do have a kind of a love-hate relationship with the attorneys, but it seems to work fairly well. I can call them and say, they know that I know my policy very well, and if I'm appealing something, there's probably something there that they need to address. Okay, there's not very many attorneys in that office, and so you can generally get to them. And sometimes they don't want to talk until there's an actual appeal filed. Okay, fine, file it. I've withdrawn a ton of fair hearings because once it gets filed and the caseworker maybe talks to her friends or, at the office and they're like, you've got a fair hearing with Todd. It's like, good luck with that. Okay. And they're like, okay, maybe I don't want to do this. And, they can, but the attorney, somehow it gets fixed. Okay. And that's your goal, is to not have to go through a fair hearing. All right. All right. So failure to respond, you did not respond to a request for documents. Okay. It happened and here we are. So number one, did you get a notice? Okay. Well, there was a time in my 25-year career where they would mail it to us. Well, the mail's not 100% and we would never get a notice, and we didn't know that we had to submit documents, and 10 days later it's denied. We get this denial saying you didn't submit these documents. I didn't know that you asked for them. And this was back in the day pre-email, but it still sometimes happens now. Some new caseworkers like, no, I'm going to mail it to you. Just email it to me. No, it's just like, good Lord, come on. And so they have to prove that you got that denial or that request for documents. Okay. So I have done fair hearings where I'm like, state, prove to me that I got that letter. And they're like, we can't. And so they're like, do we have to send everything to you certified, signature requested? Yeah. If you want to prove that I got it, yes. Or stop being ridiculous and trust me to say, I never got this, and let's carry on with the case. And those cases are really good because the judge will be like, you can't prove he got it. And I don't think you're saying he's lying. And so let's reopen the case, send the notice, and let's keep this going. It's like, okay, I win. And so if they insist on mailing, they should send it signature, certified mail signature, so they can prove you got it. Nowadays, it's almost always email. Okay, even those new caseworkers are like, this really works better if you email it, and so they typically do. So if you did not get the notice, that's an easy appeal to win because they can't prove it. If you did get the notice, then why was it not responded to? Number one, it can be the client's fault. Okay. So the client did not get you the information. You can't get what you don't have to the state. And so therefore you did fail to respond and the case is denied and it's the client's fault. Now, this gets ugly because you can very well be 2, 3, 4, 6 months into this process when it gets denied. And now you've got 6 months of nursing home bills that aren't getting paid for. Someone's on the hot seat. Okay. And if you're trying to tell the client who's now broke or they've spent their money appropriately in a married case, they've got to come up with $30, $40, $50, $60,000 to cover that period of time. It gets ugly. Okay, even if it is the client's fault, they're like, well, you didn't tell me, or I didn't know this. And so you have to advise them in writing. And we pretty much, once a client hires us in our office, we tell them, we want written communication between the two of us. You can call the office, but I'm going to send you an email that summarizes our phone conversation. If you see something in that email that's not right, you let us know. But we highly encourage texting and emails because it's in writing. Miss Jones, I need these 4 bank statements and this insurance statement. Okay. And if they didn't get those and they're like, you didn't tell me, yeah, I did, email February 18th, I sent you this email requesting that and you didn't get it back to us. Okay. It gets very confrontational. And so I just absolutely put it in writing. Um, if it's your fault, that's obviously not good. Okay. Sometimes deadlines get missed and things happen. And this is where your caseworker having a good relationship with the, I call my person a case manager. The DHS person is the caseworker. So just so my case manager works with the caseworker and say, oh shoot, I'm sorry, I thought that was in that email. I'm sorry, can I send it today? And if they have a good relationship, they're like, yeah, that's fine, just send it. But I promise you, they can stand their ground and say, 10 days, you didn't get it to us, you're denied. And that's where, they are being a little ridiculous. A person is applying for a tremendous benefit that they need to pay for this expensive nursing home. And you saying, yeah, you were 1 day late on a bank statement plays to our sympathy, to the judge's sympathy on our side very well. And that's where I will eat the caseworker's lunch. And I'll say, you're denying them $50,000 worth of benefits over 1 day. How could it have harmed you in any way to accept this bank statement 1 day late? How is that even comparable damages? 1 day late on a bank statement, $50,000 worth of expense that has to be paid now. There's just no comparison to it. And I'll talk about later, don't expect to win a fair hearing because it's very cut and dried and your hearing officer is a DHS employee. And so don't expect to win fair hearings, but to a judge, a real judge, that really plays a part. So seriously stay 1 day late on a bank statement versus $50,000 worth of damages, it plays very well. And so a lot of times, if it is your fault that you didn't do it, you've got to beg for mercy. You've got to, hope that they have a good relationship and they fix it. And then about your only argument, if you have to go to a fair hearing and you don't win, that is undue hardship. And there's no definite definition of a undue hardship. All right, sometimes you didn't spend enough money, okay? And that's a problem. The client is still over resourced. So typically that's when assets were missed. So if you or the client really messed up and didn't report something that was there, there's really no need to appeal. It's like, whoops, forgot about this insurance policy or this, bank account that we knew it was there and we forgot to include it. And yeah, it's messed up. Okay. Now, there are sometimes you can find a resource that's not that much. Like there's this forgotten checking account. And a lot of times with these cases, you've got the kids coming in to do this for a single aging parent that's now going into the nursing home. And so the kids don't know everything that's going on with the mom. Okay. And it's easy to forget a bank statement or a bank account. And so, I have found the state to be pretty good to say, look, I'm dealing with children of this mom. She was very private about her banking, and we just found this bank statement or this bank account. And a lot of times, what they'll do, again, good relationship helps to say, hey, it's $2,000. Come on, yeah, she had $1,500, which was under our limit, and we found this other account that now throws her over. But we're 6 months into this application. Can we just, pay that extra to the nursing home, or maybe be disqualified this month rather than going all the way back to the application date? And they do have some flexibility there to do that. And this is where the attorney, if it goes to a fair hearing, a lot of times the attorney will say, yeah, $2,000. Yeah, we'll make this, we'll figure it out somehow. Okay. And so again, undue hardship, you're going to go back 6 months over $2,000, costing us $50,000. That's a problem. And so there is this undue hardship argument. If it's a big amount, if it's like, oh, the $100,000 IRA out there that no one knew about, yeah, that's a problem. Okay. And so you just got to sit down and talk to the client, say, yeah, they weren't qualified. This is a problem. But the good thing is you have $100,000 to pay the $50,000 bill. So, you know, it does happen. And if you truly, truly forget, then it's okay. So it's a good idea in your initial meeting with the client is to, our subsequent meeting, once they bring in all the documents and you're like, okay, here's where I'm seeing the assets are, put that in writing and have the client somehow acknowledge, yes, this is all of the assets. And then when you're denied because an account was found, it's like, oh, that's not on this list. I can't go find it. You told me this was the list. That's incorrect. And so this is a problem. All right. And I would tell you, our state does it. I'm sure all the states do it. They will find accounts. They have some voodoo software out there that will find accounts. And we're always, particularly on the single parent kids doing it, very frequently the state's like, yeah, y'all forgot about this bank account. Typically they're closed, and that's a whole nother issue. But anyway, okay. So found assets. If you just found the assets well into the applications that aren't huge, the state will sometimes have grace on you and say, okay, just pay it to the nursing home and we'll adjust the payment and we're fine. Okay. Be honest. Okay. You can't get by with this too many times. I mean, do your due diligence and try to find assets. But every now and then when you say, hey, we just found this, again, good relationship between your caseworker and the case, or your case manager and the DHS case worker, then it hopefully will work out. But honestly, you're over resourced and there's really no need to appeal that if you can't get it worked out with the caseworker. Do a thorough search before the application. Okay. Yeah, being over resourced is not a great appeal. Now, rung snapshot. Okay. Again, this is with the married case, and it's like, uh-oh, we didn't spend enough money. Okay. Or the snapshot amount that we thought we had, we spent half, wasn't the right amount. And so the community spouse is still over resourced. Institutional spouse gets denied. Again, who missed it, what happened, do a really good job, have your clients' children do a really good job of figuring out where the assets are. Now, sometimes you may have multiple snapshot dates, okay? And again, just to review, the snapshot date is the first day of 30 days in a nursing home or a Medicaid application. So with the Medicaid application, that's pretty set. But if it's the first day of 30 days in a nursing home, you can have multiple segments of that over time. I actually did a case that we did 4 fair hearings on. Crazy case. And actually in the last fair hearing, the judge, we were arguing over the amount of assets on the snapshot date, and the state was wanting to do this one and they were ignoring some things, but the judge was like, well, you made some reference to him being in the nursing home back in 2020. And we're like, yeah. And she said, was it for 30 days? And we're like, I don't know. And she said, well, let's pause this hearing. Y'all go do that research. And if the snapshot date is back then, the money was obviously in the bank account, increased the snapshot date, and we were good. And so we actually went back and pulled records and said, yeah, the snapshot date was 2020, not 2022. And it fixed our case. And it's pretty cool. So you can pick and choose which snapshot date fits your assets the best. And if that doesn't make sense to you, call me and we'll discuss it. Okay. All right. Policy disputes. Okay. Federal law says this, your state hopefully accurately reflects federal law as to how your state's going to do Medicaid, and they're not following federal law, or sometimes they're not even following their own policy. Okay. They're not applying the snapshot date right, or they're not allowing this asset to be counted or not. There's a policy dispute. This is where you can really make a difference for your client, but you're also doing it for what I call the better good. You're doing it for other elder law attorneys in the state and other clients, other people, future Medicaid applicants who need you to get this fixed. Okay. Now, realize sometimes the state Medicaid office they just don't do what the rules say. All right. And there's some things Arkansas does that's actually in our benefit that's not following federal law or their own policy. And I'm like, it's helping my clients, so I'm not going to argue with that. But there are some times when they just don't do what the policy says. And they're like, yeah, we just don't want to do that. Okay. Well, that's where you need to step in and fight. Okay. So if the policy is not clear, but it's been litigated and settled, there's no need to appeal. Ask around. I think most elder law attorneys would rather you not mess up how things are right now. And so if you know someone in your state who's done a lot of Medicaid and probably done some appeals, if you have a policy issue, I would call them and say, hey, I've got this policy issue that I've been denied on. Has this been litigated before? In some states, you have access to the fair hearing decisions. We don't in our state. And so it's all kind of word of mouth between the attorneys. And so I have people call me fairly frequently to say, hey, Todd, we're about to do this appeal and this is the issue. I'm like, nope, stop. That's set. We've appealed that. It's been done. So like one issue real quick is in Arkansas, if a community spouse after the institutionalized spouse has been qualified for Medicaid, okay, we did everything right. They're broke. They're on Medicaid. Now she has some money and different things. In Arkansas, when she sells her house, all of that money, all of the proceeds of the sale of that house go to the institutional spouse. Absolutely violates federal law. Absolutely, it just makes no sense to me. And I've appealed it twice. I won once and I lost once. And when I lost, when I lost, the client's like, I'm tired of fighting. I don't want to appeal this. And so we didn't. And so we have a split decision. And so when attorneys call me and say, hey, Todd, community spouse wants to sell their house, she can do that, right? I'm like, well, yeah, but all the money goes to the institutional spouse. And I fought it, and just know that if you do a fair hearing on this, you're going to have to appeal it into court and probably even appeal it further from there. So do you really want to do that fight? And so that's an example of where there's a policy dispute. The state doesn't follow what the federal law says, but we just kind of live with it because to fight it's going to be extremely difficult. Don't appeal something that can mess up things for others. Okay, that's a very common. Bad facts make bad law, and if you have bad facts, or you just be careful. I encourage you to appeal cases that need to be appealed, but I would, if you're new in this, ask around and get some consensus from other elder law attorneys. Like, hey, should I appeal this? All right. Do you charge or you don't charge for an appeal? Well, if it's your fault and you need to appeal, don't charge. Okay. You've got to eat that because you're trying to cover yourself. It's like, we got this notice of action, didn't send it in, don't know why we didn't, it's got denied, and we're on the hook. Okay. So obviously don't charge. If it's not your fault, okay, but if this is one of those policy issues that you really want to make known and get fixed, I do those for free. Okay. I mean, I try to charge. I'm like, hey, this needs to be appealed. I charge $2,500. And they're like, oh, I just can't do that. It's like, don't worry about it. I'll do it for free. Because it's really not hugely time consuming into the fair hearing. Once you appeal from the fair hearing to the circuit court, that gets expensive. But a real fair hearing, you've done all the work. You've just got to carve out a little bit of time to do it. And so I will do it for free. But if it is truly the client's fault, then I'll have a conversation with them. It's like, you didn't give me those documents and this is denied. I can appeal it. I don't know if I'm going to win, and I'll tell you in just a second, always tell your client, we're probably not going to win this. Even if it's the best facts in the world, just know we're probably not going to win this because chances are you're not. That doesn't mean the case is over, but just at the fair hearing level, you're probably not going to win. Okay. So, you can't leave a client in a bad situation if it's their fault and they don't want to pay for the appeal and they can't pay for the nursing home. It's an ugly situation, and I don't know how to get you out of that other than if you just suck it up and say, okay, we have to reapply. You know that you messed up, we've now fixed it, so let's just get, and that second application should be pretty easy. And so typically what I would do, and I'm not saying you have to do this, what I would do is if it was the client's fault and it's an easy fix, just do the application and move on, okay? Practice point. Put in your contract that your fee that you're charging for this application is earned and over with when you have a decision from the state. Not an approval, because you don't know that you're going to get an approval, but when you get a decision back from the state, that's when your contract is over with. So therefore, the appeal is outside of your initial contract and is up for discussion. All right, here's the process. So you've been denied, you want to appeal, you have to send a written appeal. Yes, I want to appeal this denial within a time limit. It's typically 30 days. Okay. If you mail it, send it certified so that you can prove that they got it. Obviously, there's a time deadline, and you may need to prove to the judge, I sent this to them. Okay. If emailed, request an acknowledgement of the email from the recipient. Okay. Now, once you've appealed, they've gotten your appeal, you will get a letter from the administrative judge that basically states, yep, I got it based on this client's Medicaid application, and here's your date, or I will eventually send you a date, okay? You will be sent a date. If that conflicts with something that's going on, just call them. They're used to dealing with attorneys. Just call them and say, hey, that date doesn't work for me. We need to scoot it out typically. There will be information in this letter about how it will be done. If this is your first time, I encourage you, call me. Let's talk about it, okay? I will talk to you on the phone and say, okay, your first hearing, here's some things to be concerned about, okay? Won't charge you for that. Just call me. Let's just talk about it, okay? But it will tell you what to do, okay? It will also allow you to subpoena records. Now, you typically don't have to do that because you will get a complete file from the caseworker, a complete what they've worked on this case. You should get that typically by email. And so you'll get everything from them. However, I will tell you, if part of your if your appeal is based on the caseworker's actions, like in a email or they're just being difficult, you may need to subpoena their records. You should have it from your emails when they email you because you saw it, obviously, but sometimes that's about the only time I've had to do a subpoena was to get their inter-office communication records. Before the date, you should get the hearing packet, and it's notorious in Arkansas. I show up at the fair hearing, I'm like, Judge, I never got the hearing packet. No, I thought I sent it out. Well, you didn't. And so a lot of times I don't need it. I know what's going on. I know what the process is, but just know you should get a hearing packet before the date of the appeal. Okay, go through this, see what's going on, see what the caseworker was doing. And then on top of that is the hearing statement. And that's a condensed version of the appeal. This is what the state says, okay, here's why this was denied. There should be a policy statement so that they're referring to a policy to say this was denied because of the wording in this policy. Don't be surprised if it's wrong. Okay. Meet with your client and those on your side who will need to testify. Okay. Bring them in beforehand, just kind of talk them through this process. And honestly, if it's a policy dispute, if there's not facts at issue, it's just this policy, you're not following this policy. A lot of times the witnesses won't say anything, but in every hearing I've done, a representative of the applicant has to be there. Someone's got to be there. And I just tell them, look, either be on the phone or be there. I don't expect you're going to say a word. It's all me arguing policy with them, but you do have to be there. Go over the facts with the client, let them know what the issue is, why this is being appealed. And it always helps if you do litigation, you probably know to do this, but if you don't, remind your clients, look, this is a court case, okay? They'll ask you questions, I'll ask you questions, there'll be objections, and if there's an objection, stop talking. And just know that if the opposing attorney won't let you fully answer your question, it's like it's a yes or no answer. It's like, well, yes, but, and they won't let you do the but. Just know I'll come back and say, look, Sally, you said yes, but you wanted to say something else about this question. Go ahead and tell the judge what you wanted to say. And so just reassure them to know that that opposing attorney is trying to get very specific information. And if they don't let you explain, I will jump in and I will make sure that you can explain. So don't get frustrated. Just stop talking. Okay. Know your policy. You have to know your policy inside and out. And I would surely hope that if you're going into a fair hearing dealing with a policy, and the policy is going to be on that hearing statement, you'll know what the policy is before you get into the hearing, but you probably should have some other policy to counteract that or do whatever. Know your policy. Okay, the actual fair hearing. Realize this is you and your client versus the hearing officer who is employed by the state, DHS office typically, the caseworker, and the DHS attorney. It's 3 against 1. It's not a fair hearing, but that's what they call it. Okay, it is usually on the phone. And so being on the phone I don't litigate. And so I guess if you litigated during COVID, you kind of got used to video or whatever. But to me, being on the phone seems kind of unofficial, laid back, hey, but understand it's being recorded. And the only thing the circuit judge is going to see is what is on that piece of paper, the transcript of the hearing. Okay. So you've got to be on your toes. You've got to treat this like a real trial and object and be aware of what's going on. I lost a case because I did not object in time. It killed my soul. Okay. Treat this like a real hearing and object appropriately. Now, I think what you may find interesting if you are a litigator in Arkansas, and I would assume this is most states, hearsay is allowed. Oh, the caseworker said this and they said this, and you're just like, wait, you can't do that in a court case. But yeah, you can. It is extremely frustrating, but a lot of times it's like, yeah, so Ms. Jones, what did the caseworker tell you, or what did the nursing home tell you, or and I can ask Sarah, my case manager, what did the caseworker tell you on this? And it's just a free for all. Okay, so just understand, but you can use it to your advantage. Sometimes the judge will let you do an opening and a closing statement. I rarely, sometimes if like it's a policy, I want to plant in the judge's head from the very first, okay, we're going. I want them to know what this is about. So I will do an opening statement to say, you will see, blah. And then I definitely do a closing argument. Okay. Oh, let me go back. You may think that's the last thing that your client will remember. Sometimes you're doing a fair hearing mainly for the client, okay, to know that, hey, I'm trying to fix this. I'm doing everything I can for the client. And so you do want the client to remember, hey, I am fighting for you. And so that's not a misprint. Okay. Everyone who testifies obviously has to be sworn in, okay? You would tell who is in the room, okay? Since it's on the phone, they can't see. And so a lot of times you do have to tell who's in the room. And there's a lot of times I will have other attorneys who are either learning or my client says it's okay that they're there. You want to get their dandruff up real quick. If you're doing a policy case that's really sensitive, invite the press. If your client allows the press to be there, because they're probably mad too. And it's like, yeah, bring the press in. I've never done it, but I've threatened it, and everyone just gets their dandruff up. It's like, well, if my client allows it, it's fine. And anyway, I like to poke the bear every now and then. Now, even though there's another attorney in the room, sometimes the ALJ will not let but one attorney conduct the hearing. Okay, so just know that there's rarely, I've never been able to do a co-counsel situation. It's one attorney does everything. Now, the other attorneys over there write notes and things, but only one attorney is the one in the speaking in the hearing. Okay, so the caseworker will read the hearing statement. Here's why we're here. Here's the issue. And it kind of sets the stage. And then the ALJ will say, well, based on this or that, the state, you're up first, or Mr. Watley, you're up first. It's like, okay. And then it's just basically like a trial hearing. This is a very derogatory statement, but it's always been true. Don't be surprised if your opposing attorney really doesn't seem to know what's going on. It happens. Okay. I've lost fair hearings that it just kills me, because like I knew this way better than they did, and they just had, it's a fair hearing. It's a DHS fair hearing. It's not fair. You're probably going to lose. All right. After the fair hearing, you will probably not get a decision in that hearing from the ALJ. They'll say, okay, testimony's done. Thank you. I will get you a letter out within 30 days. Click, over. Okay. So you will get that later. I did have one ALJ. It was perfect facts, slam dunk case. And the judge is like, yeah, Mr. Wiley, you win. They should not have imposed that penalty. Thanks, judge. Over. And so, but I've done a lot of these, and that's only happened once. Expect to lose. Okay. Unless you have absolutely clear policy that cannot be interpreted in any other way than the way that it says, and the facts fall clearly in your favor, expect to lose. Okay, just expect to lose. It's okay. Okay, it's not a fair hearing. The next level will be much more fair. I always call that real court. That's going into circuit court with the judge who's not paid by DHS, who will, I think, more honestly look at the facts. And I've done much better. I've won very few fair hearings, but I do very well in circuit court. Okay. And tell the client, set expectations. Look, this is not a fair hearing. It's 3 against 1. It's 3 of them against us 2, and expect not to win. Okay, but that's not the end of the story. There's another step, and we will talk about that if we do actually lose. But I'm just telling you, expect to lose. Now, you lost. Okay, all right, we lost. If it was a bad case and the ALJ was right, this is, hey, I told you we were going to lose. I didn't feel great about going into this case. Now what? And figure out what to do. Like I said, let's redo the application. I'll do it for free. Let's go. Okay. You really do have a heart to heart with the client to say, look, we're going into real court now. Okay. We have to pay a filing fee. There's going to be transcripts. There's going to be some expense here that is real, and you do have to spend a significant amount of time, because you'll see in a second, you probably want to do a brief. Okay. And so a brief takes time, and I've not gone to court a lot because my client's like, okay, we lost. Let's figure this out and be done with it. But just know it is fairly time consuming going into court. And most clients won't pursue. If you're demanding that they have money to go that next step, most clients won't do it. Now, if the ALJ is wrong, okay, and this is worth pursuing, it's one of those issues that's for the better good, at least get the filing fee from your client. Say, look, I'm going to put a ton of work into this. I think it's worth appealing for the better good of everyone in the state. Let me appeal it. I'll eat it. Okay. And I know you don't like that, but sometimes you just got to eat it to make the world a better place. You do have to pay to appeal. Okay. You're opening up a court case. This is not a de novo appeal. You are stuck with the record. And that's why you have to go into that fair hearing thinking this is all the judge is going to see. You have to do that correctly. All right. And I am winding down, I promise, to give y'all some time for questions. once it's filed, ask the judge if they will accept briefs. You want to submit a brief because these judges have no idea what you're talking about. They don't do Medicaid appeals. They have no idea. They were probably not a Medicaid attorney when they went to the bench, and so they have no idea. You want to do a brief to explain the process. It's your job and the state's job to educate this judge on what we're arguing. They don't know what a snapshot is. They don't know what spin down is. They don't know what countable, non-count. I mean, they don't understand anything about Medicaid, and your brief has to educate them. And sometimes I think the best brief wins. Okay. The hearing is essentially you reiterating your brief. Judge, here's what's important in this case. Here's how the caseworker did not follow and the ALJ misinterpreted. This was just, I should win. Okay. And probably the most frustrating I've ever been is when the court was just like, Mr. Watley, I don't fully understand this, but I'm sure the state's right. Okay, Judge. And they just don't want to put in the hard work to do what needs to be done. But I've been fairly successful, but I've lost a few just because they're like, Mr. Watley, I'm sure the state's right. That's a great assumption. Okay, practice tips. Fair hearings are a pain. Okay, it messes up your day. It's not what you normally do, but we want every Medicaid case to go as planned, that we get an approval and we move on to our next case. That's how we want, but sometimes it just doesn't go that way. If you do enough cases, you should have to appeal at some point. Don't panic. It's okay. You know this stuff probably absolutely better than the caseworker does, and you probably know it better than the attorney does. I promise you, if you do your homework. Appeals can be good for the better good. Get help, okay? Like I said, run your denial by some other experienced attorneys in your state who have experience doing fair hearings. They will help you on this. They may not help you on how to develop your business or start, but they probably should want to be involved on fair hearings to advise you, no, don't appeal that. Or yeah, that's a great case to appeal, okay? If this process scares you, get a mentor, okay? And an in-state attorney is best, but if no one will help you, call me, okay? I will help you if I can, I promise, okay? All right, so real quick, well, Amber, let's go ahead and do questions real quick, and then I'll do this after questions.
Okay, perfect. We do have a couple of attorneys asking for a copy of the slides that I can get from Trisha and just email out to people. So that was one of the questions. And then we have an attorney on from Kentucky who indicated that their state just issued a regulation that caps the amount of what's considered reasonable attorney fees in a spend down, which is hampering a lot of resubmission efforts, even when it's the agency's mistake. Have you heard of other states doing this? Do you have any suggestions on that?
That's interesting. Yeah, we need to be made aware. NALA needs to be made aware of that, and I would think even NELF. They have litigation funds that can fight that. I think Alabama did that. They capped fees at like $3,000, and I mean that's just a complete violation of freedom of speech and contract. I mean, there's just so many things wrong with that. I forget how Alabama fought that, but I will follow up on that because that's huge. And so we need to fight that. And did they say how much the fee was? I'm just curious.
Not yet. Let me see if she's still on here too.
Okay. Yeah, that's ridiculous. So, all right. Some other questions?
15,000, it looks like.
Okay, well, that's better than 3,000. But okay, but still, you should not be limited. Okay. All right. Yeah, I'll follow up on that and we'll address that one way or the other.
Okay,
Any
yeah, that
questions?
was the only question other than about a copy of the materials. And so if you want to go ahead and close, go ahead.
Okay, sure. So I just want everybody to know that I do coaching. Okay. I love to teach. I've been doing this 25 years. I've trained a lot of attorneys to become elder law attorneys. And it just got to where people were calling me from all over the country to say, hey, Todd, please help me. And so I turned it into a business. Okay. I learned this the hard way. I did not have a mentor. There was only one elder law attorney in Arkansas when I started doing this, and he was not helping anyone. And so I had to learn this the hard way. It took 5 years, made a lot of mistakes, wrote some fairly sizable checks to cover my mistakes. It was ugly. Um, I've discovered a way that I can cut that down pretty much if you'll listen to me and do what I tell you. A year, I can make you a very proficient elder law coach or elder law attorney. Okay. I will teach you, I will mentor you and help you hard for a year to get you doing what I think is the best job in the world. I am doing a huge event in August. Okay. It's not too late. Sign up for the August 2024 push. It's a full month of content. Every working day in August, you will get something sent to you. But the big thing is on Monday, I'm going to send you fact patterns of a specific type of Medicaid or elder law case. First, it's going to be Medicaid, then estate planning. And I will send you fact patterns. And then on Wednesday, we do a live webinar from 12 to 1 Central Time where I will go through those facts, show you the type of client that comes to us, the problems, how to solve the problem, fees charged, whole 9 yards. I will give you exclusive access to podcasts that I will do just for this group. So it's going to be a big month, and I'm going to give out a ton of information, and I would love for y'all to sign up. It's free, absolutely free. And I would love to see y'all there. So go to theelderlawcoach.com. Scroll down just a tad. There's a big thing underneath. When you first see it, it's like, well, there's nothing here. Scroll down just a tad. There's a sign up form, and I would love to see y'all there. Okay. All right. Anything else, Amber?
Not on my end. I just want to thank everybody for joining us today. Thank you, Todd, for the great presentation. And if anybody has any follow-up questions, feel free to reach out directly to Todd or to myself. Both of our contact information is on the screen now.
Yep. Okay. Thanks, Amber.
Thanks, Todd.
Okay. Bye.